Let me ask you a question. Have you ever been taken to court for something you didn't do? Well, it happens. I want you to imagine for a moment that you're the owner of a freight broker company. It's a rather large company. You're moving a lot of loads. And one day you've got a truck driver that's moving a load for one of your customers. And on the way to delivery, the truck driver gets into a serious accident that results in the death of two people. Sometime later, you get a summons. You go to court and you find out that you are liable, partially liable, for the death of those two individuals. How can this happen? It happened either because you were negligent in selecting your carrier, or you exercised so much control over the truck driver that you broke the independent contractor relationship and you assumed liability for the wrongful conduct of your truck driver. My name is John. I have a company called Atex Freight Broker Training in El Paso, Texas, and we're going to explore this a little bit further here. I'm not an attorney, but it's imperative for freight brokers to understand how they can become liable for the actions of others. At first glance, it may seem, well, why am I liable for something that someone else did? So let's take a look at some new materials I'm developing. I'm doing a series on legislation and other related legal issues. And in particular, we're going to look at negligent carrier selection and vicarious liability. Okay, let's go on to the next scene.
Hi, this is John again, and today we're going to look at Session 9, Legislation and Related Issues. And inside of this particular topic, we're going to focus on 9.7 down below, some other issues, but I just want to give you a brief overview what's in store for Session 9. First, there's the introduction, and then there's CSA 2010, MAP 21, the FAST Act, CARB, that stands for California Air Resources Board, and then there's a topic on hours of service, ELDs, electronic logging devices, speed limiters, and a couple other topics. But today we're going to go into 9.7, and we're going to focus on another issue that's extremely important. So here we are here in 9.7, and as you can see, I've got 9.74 highlighted, and that's what this particular session is all about: vicarious liability and negligent carrier selection. Some of the other topics we'll get into in another day: the new food shipping mandate, driver training, CDL training for military vets, national carrier hiring standards, independent contractors and owner operators. Now, these are a few of the topics that are currently being discussed. And of course, there are other topics that we could get into, and we will over time. But let's take a look at vicarious liability and negligent carrier selection. When a freight broker is thought to be either negligent in the selection of a carrier, or in one way or another becomes liable for a carrier's or driver's conduct, where the driver's conduct is imputed to the broker, and the broker then assumes liability for the consequences of the carrier's damaging act. In this case, the broker may need some serious legal help. These are two examples of brokers becoming liable for the conduct of their carriers: negative carrier selection and vicarious liability. So let's go a little bit further. Here are two examples. In the first one, Schramm versus Foster. This was 2004. This was before CSA 2010 came into play. But in this particular case, the court emphasized the fact that brokers need to exercise due diligence, and they were supposed to use reasonable care in their carrier selection. But the courts did not go ahead and define what is reasonable care. Now, 2010 came along and replaced the SafeStat scores, and it didn't make things any better. In fact, the confusion still exists today. But this is one particular example of how you as a broker can become liable. Now, there's a second case, Spurl versus Henry. Here the broker exercised too much control over the driver, and the broker lost their independent contractor relationship and thus became liable for the driver's misconduct. In both of these cases, C.H. Robinson was one of the co-defendants. In both of these cases, there were one or several deaths that occurred as a result of the truck driver. Of course, the truck driver becomes primarily liable, but in vicarious liability, the broker may also assume liability. So let's move on. So in the first example that we mentioned, dealing with negligent carrier selection, nowadays we have 2010 in place, and the scoring system, well, 2010 set up 7 categories of behavior for truckers and motor carriers, and there was a scoring system that was set up. Only 5 are available to the public, but this scoring system was never meant to be a rating that third parties were to use to make a selection. And yet that is what is going on nowadays, and I'll tell you why a little further down. But CSA 2010 was meant to be a system for the FMCSA, that's the Federal Motor Carrier Safety Administration, to prioritize carrier conduct for potential FMCSA interventions. So it was a tool for the FMCSA, and yet freight brokers became under the gun mainly through state laws as attorneys sought to find weaknesses in the freight broker's selection of a motor carrier. So in numerous cases, attorneys have been very successful in adjudicating freight broker liability for the carrier's wrongful conduct simply because the freight broker did not pay attention to the FMCSA carrier ratings. Now, in reality, at the federal level, the freight broker is only obligated to use the FMCSA authorized carriers without using any other prerequisite hiring standard. The FMCSA, and only the FMCSA, should determine which carriers are licensed, authorized, and insured to perform interstate commerce, and brokers should be able to rely upon the FMCSA's determinations. Freight brokers should not have to second guess what is going on with the FMCSA. Henry Seaton, transportation attorney, explains it very well in a number of his blogs and in one particular book. Henry Seaton states in his recent book, Rules of the Road, that intermediaries should limit their due diligence to making sure the carrier is properly licensed, authorized, and insured. He goes on to say that any additional investigation may simply become fodder, inviting plaintiff's scrutiny and seeking weaknesses in a broker's due diligence or negligence. So on the one hand, you've got the courts saying that brokers must use reasonable care as they do their due diligence, and yet they don't explain what that is. And then on the other hand, Henry here is saying that really all a broker needs to do is make sure the carrier is properly licensed, authorized, and insured. The FMCSA should make it clear that a freight broker can rely upon the agency's ultimate determination of a carrier's fitness without fear of being charged with vicarious liability or negligent selection. Henry Seaton believes brokers need only to rely upon the principle that safe to operate is safe to use. That is, if the FMCSA determines that a carrier is safe to operate, then brokers should be able to rely upon that and rely upon the fact that the carrier is safe to use. Now let's look at vicarious liability. To avoid this liability, brokers need to work with carriers, telling them what to do rather than how to do it. That is, don't exercise too much control. This is the simple solution. Anything construed as exercising too much control may get a broker into trouble. I mean, big trouble. C.H. Robinson, I believe, was hit for $23 million in one of the examples we mentioned above. And there's been other penalties handed out up to $12 million and I think $4 million in another case. Now, a broker may have some contact with the driver. They have to tell the driver where to pick up and where to deliver and so on and so forth. But they want to keep the discussion to what to do rather than how to do it. So the broker needs to study and pay attention to these issues on how they work with carriers and drivers. So in summary, as a broker, you need to study these issues and keep up to date on what's going on. There is so much more to be said about this and some of the related issues. You might want to consider our program. In our comprehensive freight broker training, we go into much greater detail, and we provide some industry resources where you can follow and keep up to date on what's going on. So this is John with ATEX Freight Broker Training, Inc., and you can find us on the website at atexfbt.com. That stands for FBT stands for Freight Broker Training. So it's atexfbt.com. I'm in El Paso, Texas. Email me if you have questions. Email me at info@atexfreightbrokertraining.com. Thanks for watching. Have a good day.